I'm Scott Wishart, professor of comparative law and international relations at the University of Navarra in Pamplona, Spain. I've been asked to speak briefly, drawing a comparison between the common law legal tradition and that of the continental civil law legal tradition that we have here in Europe. Now, to help us better understand these two legal traditions, we need to know something about their respective histories. The civil law dates back to Rome and the Roman Senate. And as the Roman Empire grew and expanded, so did her legal tradition. But we know that Rome fell. And after the fall of Rome, her legal tradition became mixed across Europe with a combination of local tradition and custom. And by the mid-1700s, such was the state of the law in Europe that a very famous French scientist, Voltaire, is said to have said that as one traveled across France on horseback, they encountered more legal tradition variation than the number of horses that it took to cross France. Now, this condition of a mixture of local custom and tradition with Roman law continued until one man, Napoleon, codified Roman law and established what we now refer to as the basis of the civil law tradition, the Napoleonic Code. So that's the origin of the civil law tradition. What about the origin of the common law tradition? Well, we know that the common law tradition dates back to October 14th, 1066. We think it was a Wednesday. Now, how can I be so specific as to the origin of the common law legal tradition? Well, that was the date of a battle, the Battle of Hastings, when William the Conqueror invaded the British Isles to take the crown that he felt was rightfully his. Now, as King William established his new kingdom, he sent representatives of his royal court out into the countryside to help the people solve their problems. In essence, in doing so, he created the first judges in the British Isles. And he instructed these first judges to write down their decisions. And in doing so, he established the tradition of precedents that we have in the common law tradition, cases from the past that help guide the court in their decision-making to the present day. So this was the origin, this is the origin of the legal tradition of the common law. And in comparing it to the legal tradition of the civil law, because we're talking about judge-made law in the common law legal tradition, let's compare the roles of the judges in the two legal traditions. The role of the judge in the civil law tradition is everything. He or she is in complete control. She gives instructions to the lawyers as to how she wants the trial to unfold. She instructs them as to the order of the presentation of evidence, and she deposes the witnesses. She's the one who asks them the questions. So how do we compare that to judge-made law in the common law tradition? Well, it may surprise you that even though it is judge-made law, the role of the judge in the common law legal tradition is very different from that of the role of the judge in the civil law legal tradition. It is still her courtroom, but she serves as a referee for the battle, in essence, that's unfolding in front of her, the fight between the two lawyers that are representing the parties to the case. Now, we refer to this legal tradition as the adversarial tradition. We refer to the legal tradition of the civil law tradition as the inquisitorial tradition, the question and answer tradition. Now, the adversarial tradition of the common law actually dates back to Viking law and has its origins in the principle of trial by battle. And for this reason, the role of the judge in the common law tradition, serving as a referee to make sure that the battle that unfolds in front of her and or a jury is a fair one, and that the rules of procedure are followed. Now, when I began teaching comparative law at the University of Navarra years ago, one of my students raised her hand and she asked a very simple question: common law versus civil law, which one is better? Now, I have to admit, I hadn't anticipated the question, but if you stop to think about it, it's like comparing apples and oranges. They are each equally delicious, but distinctively different in their nature and their taste. The strengths and weaknesses of these two legal traditions, however, provide some insight into their differences. As we know, the origin of the civil law tradition is the Roman Senate. That is a legislative tradition. And so legislative law, civil law, is strong in the sense that it is many minds coming together in the legislative process through negotiation and debate and deliberation, many minds coming together. And this arguably is a strength because it has the tendency to create law that is more consistent, possibly over time. But that strength, more consistency over time, is also a weakness because we know that the legislative process requires time, and so it's slow. So let's compare this to the common law tradition. The common law tradition, judge-made law, has the capacity to be relatively fast. Here you have a judge given the power to solve a problem. And in doing so, they can do so relatively quickly, possibly more quickly than a legislature. So that's clearly a strength of the common law tradition, but it's also a weakness. Because if you stop to think about it, the fact that each judge has the power to make their own decision, you have the potential for two judges to reach opposing decisions in the same jurisdiction. And at that moment, these two opposing decisions cancel each other out. And at that moment, we have no law on that question until it is resolved by the next higher court on appeal. So these are the two legal traditions, the civil law and the common law. They have very different histories, very different histories of development, but they go about solving people's problems in equally strong and beneficial ways. Again, it's like comparing apples and oranges. Each have distinctive natures and distinctive tastes, but they are each equally valuable to us in society today. Thank you.